You ever have one of those moments? You're standing at your window, you look out at this perfect view, and you just think, yeah, this is why I live here. But what happens when that perfect view suddenly disappears behind your neighbor's overgrown bushes? Well, today, we're going to dive into a pretty wild legal case that started with exactly that, a simple homeowner complaint, and then spiraled into this multi-year battle that literally changed the rules of the entire community.
So let's just start with this question. What is your perfect view worth? I mean, really think about it. Is it worth a quick, maybe slightly awkward chat with a neighbor, a formal complaint to your HOA, or is it worth a fight that goes all the way to a judge? Well, for one couple down in Arizona, the answer was absolutely clear, and it took them on a journey you really have to hear to believe.
All right, so let's meet the folks at the center of this whole thing, George and Carmen Rose, and really unpack the problem that would kick off this entire saga.
So picture this. It's June of 2004. And the Roses buy what they think is their absolute dream home in this gorgeous Arizona community. It's right on a golf course lot, promising those incredible views. But there was one pretty big problem. Their neighbors, the Millers, had some landscaping that was blocking their prime view of the 14th tee. And to the Roses, this wasn't just, a couple of annoying shrubs. This was a major obstruction to the view they believed they'd paid a premium for.
So what do? You go to the rule book, right? The Roses looked up their community's governing documents, the CC&Rs, and they found this. I mean, it seemed like a total slam dunk. It says right there in black and white that landscaping should be planned to, and I quote, avoid undue obstruction of the view. So you can imagine how they felt. They probably thought, case closed. We've got him. What could possibly go wrong?
Well, what started as a pretty simple dispute between two neighbors escalated, and it escalated quickly. The Roses took their complaint to the one group they thought could fix it, the Homeowners Association Board.
And wow, things moved fast at first. By mid-August of 2004, formal letters are going out. Just a week later, both the Roses and their neighbors are standing in front of the board, pleading their cases. But the board, they were kind of stuck. They weren't sure how to interpret that undue obstruction phrase, so they did what boards usually do. They called in the lawyers. After a month of legal back and forth, the decision finally came down on October 26th, and it was a big no. The board officially denied the Roses' request.
Okay, so here's the board's logic, and you really got to understand this part. They argued that they had already taken action. See, they went out and trimmed some bushes on the common areas. That's the land the HOA itself controls. In their minds, doing that gave the Roses a reasonable view. They weren't about to step in and force a private homeowner, the Millers, to start ripping up their own backyard. As far as the board was concerned, they'd done their part. Matter closed.
So the Roses had hit a total brick wall. But what happens next? This is the most critical and honestly kind of shocking part of this whole story. The HOA didn't just deny the request, they actually moved to change the very rule the entire complaint was based on.
Yeah, just 5 months after shutting the Roses down, the board puts together this whole packet of proposed amendments to the community rules. They send it out to all the homeowners for a vote. And wouldn't you know it, buried in that list was a little something that seemed tailor-made for this situation, a change that specifically targeted golf views.
Now look at this, because this one sentence changes everything. The original rule, the one on the left, it's just a general principle, right? Avoid undue obstruction. But the new rule adds that one critical line. The board of directors shall be the final authority as to whether a view is unduly obstructed. Boom. With that one sentence, the power to decide was ripped away from the general rule and put directly into the hands of the very same board that had just denied their claim.
And the homeowners voted, the amendment passed, and on March 22, 2005, it was official. Just like that, the legal ground that the Roses' entire case was built on had vanished. It was erased by a simple majority vote.
But believe it or not, the Roses, they weren't done fighting. They were blocked on the golf course view, so they pivoted. They turned their attention from the fairway to the mountains. So about a year later, in February 2006, they try a totally new angle. They put in a formal request to have plants on the common area trimmed to open up their view of the Catalina Mountains. But the HOA's denial was fast and it was blunt. Mountain views, they said, just aren't protected in the rules, period. The Roses appealed, pointing to some hopeful-sounding language about respecting vistas, but the HOA shot that down too. They basically said, look, that's just some fluffy introductory language. It's not an enforceable guarantee of anything.
So, having been shut down by the HOA at every single turn, the Roses took the only step they had left. In October of 2006, they filed a formal petition and took their case before an administrative law judge.
And the judge's very first finding was a massive blow. He said that because the community had voted to change the rules back in 2005, their whole argument about the neighbor's shrubs was now legally moot. I mean, basically, you can't ask a judge to enforce a rule that doesn't even exist anymore. It's like trying to get a refund with a receipt you've already shredded. It's just gone.
Next, the judge looked at the bigger question of the view itself. And honestly, this part's pretty brutal. The ruling stated that the Roses' expectations for this perfect, clear shot of the 14T were, and I'm quoting directly, unrealistic and unreasonable. The court basically sided with the HOA, saying that just because you buy a house on a golf course doesn't mean you're guaranteed a front row seat from every single window.
And finally, on their second complaint about the mountain views, the judge was absolutely unequivocal. After going through all the paperwork, the old rules, the new rules, the court found that there was nothing, absolutely nothing, in any of the documents that gave homeowners a specific, protected right to a mountain view. The HOA's position was completely upheld.
And so, on January 23, 2007, nearly 2.5 years after this whole thing started, the battle was over. The judge officially denied the Roses' petition, bringing their long and I'm sure very expensive fight for a perfect view to a final, definitive end.
So why does this one case from a golf community in Arizona matter to you? Well, because the Roses' story, as frustrating as it is a huge cautionary tale. It's packed with lessons for anyone who lives in or is even thinking about buying a home in a planned community.
So, what's the big takeaway from all this? First, and this is the most important one, read the rules before you buy. Don't just fall in love with the view, fall in love with the paperwork, or at least understand it. Second, know that those rules are not set in stone. As we just saw, they can be changed by a simple vote from your neighbors. And here's the real kicker. A view is often not a legally protected thing unless it's explicitly spelled out and guaranteed in the documents. And, at the end of the day, remember that the HOA board usually gets the final say. What seems totally reasonable to you might have zero legal standing.
So we end up right back where we started. That beautiful view from your window, it's definitely something to treasure. But the Roses' story is a really powerful reminder to ask yourself a much more important question. Are you just admiring the scenery, or have you actually read the fine print that could make it all disappear?